This here today is really the second part of two parts of trusts. Last week was trusts, the basic, Trust 101. And I had a handout for you that I didn't give to you until later. I sent that by email in follow-up. And today I'm going to actually hand it out. And I've got it right at the edge of the table. And it's actually a pre-publication of what will be in the Brightside News. That's the news around certain parts of Marietta, and there's a Marietta edition run by different editors, editors. And as we know, the editor Alan Lipset, a good friend, he passed away, and his surviving spouse, Kathy, still operates that. So it's one of my regular articles. I would imagine it's one of possibly even hundreds that I've done in there over the course of probably 15 years or so, which 15, a little more than that, maybe 17 or so. It predates when my law firm opened, the Myring Law Firm, and as you know, I'm Robert Myring. I have a little law firm that specializes in wills, trusts, estates, and probate. So in talking about the second half of this Trust 101, and then today's session might be called Trust Advanced Trust, or let's just call it Trust 102, okay? Everything else you would want to know about trusts, and I'm more than happy to answer. This should be interactive, and I've got some basic things to cover, but last week, if you remember, we did cover the basics of who are the main characters in the trust. Somebody creates it. They're a trust creator. They're also called a grantor because they grant some property, over to the trustee, which could be themselves or it could be their trustee friend. But trustee is the second character in a trust setup, and the third person would be one who benefits from what is put into that trust. And that, even though that could be the same person, and even though it is kind of confusing when all these moving parts get moving together, your basic setup of a grantor handing over something of value, maybe money, to a trustee to spend over the time and distribute to a beneficiary under certain rules that they set up. And those rules are outlined in a trust, the trust document, the controlling document of how a trust works. And and that's kind of a review of what we covered last week about the basics of how those trusts work. Now we get into the more fun parts of what are they for and all the different purposes. And yes, question?
What is a grantee?
What is a grantee? A grantee in this case would be the trustee. Okay, so because they receive the property. So has anybody in this room ever purchased a real estate property? Show of hands? Yes, most of us have. I have too. And you end up on that piece of property that you bought as a grantee. So grantees occur in several situations, but in the trust dynamic, one who receives the property could be the same one who actually granted the property in the first place. So the trust creator takes, let's say $10 in their left hand, and then they move it over to the right hand, and now they take that as a trustee. Officially, they take it as a trustee, and they write it down and make a record of it. And they say, take that $10 and spend it for myself over the next 10 weeks at $1 a week. You've kind of effectively made a trust because the intent to create a trust has been expressed. It's been put down in paper form called the trust document, and there's something of value to spend over a period of time for somebody, a beneficiary. So you got a working trust there, at least in its basic parts. Now, the best estate planning documents are trusts. IMHO. What does that mean? What does IMHO mean?
In my humble opinion.
Correct. In my humble opinion. Right. right? Just to make sure that I'm catching the attention of my readers and having absolutely nothing to do with the point of what trusts are and what they do, is that, yes, in my humble but yes, somewhat experienced opinion, both in the drafting of trusts and in the litigation over trusts, because when there's a problem, sometimes you can't fix it without going to the court. Sometimes you mostly hope to fix it outside the court, but inside the court, that's the superior court, and having a little bit of experience on both ends of the creation and the fixing of trusts, my humble opinion is that still trusts are the best estate planning documents. It's a qualified opinion if you want to take it that way. But it also starts off that column I was talking about. I call it an article, but editors in the paper call it a column because it's a regular feature. And so that's what will be published, and this is what I'll make sure that you leave with. But in this, the reason I say that is they are the most versatile, legally effective, and protective documents of a person's estate plan or of a family's legacy plan. Okay, the three words I used there were versatile, effective, and protective. And I'm using the superlative, like most. They're most versatile. Meaning that they can have many purposes, like for protection of one's lifetime assets, from collectors, maybe from family. Probate avoidance is another purpose of trust. Trusts are versatile because they also could provide for minor children. They could provide for special needs or for management of wealth during a person's lifetime or after that, you could say wealth maker and trust maker's lifetime. Sometimes with great wealth comes great family problems. So believe me, the more money there is, the more problems that do occur. And so trusts sometimes help with that, but they're versatile. They can fit many purposes. The next word was effective. They are effective in that the trustee of a trust is legally bound, legally required to follow the rules, the terms and conditions, you want to call it that, of the trust. And they're required to make those timely distributions of money or property, be they real estate or cars or tangible family heirlooms, things like that. They are bound to make the distribution to the beneficiaries of the trust, and that trustee doesn't have to take the position if they can't handle the responsibility, but somebody else could, and the trust will go on and serve its function. But they are effective in that way, and you got the power of the courts to enforce that it will happen, or it will be corrected if it's not happening the right way. What's the right way? Well, those rules are found in the rules of the trust, in the trust document, the terms and conditions, if you want to call it that. Anyway, the last thing is that the trusts are protective, and that's because the money or the assets or property that is put into the trust can be protected from creditors. That's the creditors of the creator of a trust, the grantor. They could be called a trustor, a settlor, or just, we call them grantors most often, but the grantor of a trust, their property can be protected, and the beneficiary also. If they're going to receive, like, say, $5 million, and then the IRS is after them for $10 million, and that $5 million is set in the trust, well, the IRS actually can't touch the $5 million if the money comes out of the trust and pays for, like, shopping, gift cards for that beneficiary, and pay, the trustee pays money out of the trust for the doctor of that beneficiary or for the educator of that beneficiary. And meanwhile, the IRS with a $10,000 bill, on this beneficiary still can't collect it because that beneficiary doesn't hold a single penny of that $10 million, which they have a right to benefit from. But it's only if they actually receive it can the IRS pounce and get their at least $5 million, if $5 million is handed over to the personal bank account of that beneficiary. So there, in summary, is why, in my humble opinion, that I see that trusts are the most versatile and best estate planning documents, most effective and most protective. And yes, there was a question over here that I am more than happy to take.
Well, everything that I had always heard before was it took a lot of money or worth money to have a trust. But from the way you're sounding, it doesn't need to be that much. So how can we decide about that?
Well, that's a great question. So that is that you've heard that it takes a lot of money and or property to have a trust in the first place, but according to what I'm saying, maybe not so much. You don't need that much. Yes, that is true. You don't need so much. And where have you heard this from? The internet or from...
Probably just a mixture because it's going back in my head.
Right.
I've heard it multiple times.
Okay. Well, for one, and I'm going to get into this a little bit more, trusts can be sold to anyone by anyone. Okay, it's not just lawyers that can sell trusts. And that could factor into who might say that you need a lot of money to form a trust, because they may be looking for your money, for one, that's possible, or they have a very rigid understanding of what trusts are, and they manufacture trusts. And as I say in the column I wrote here, and I'll have a handout for you at the end of class, that there's no laws, and there's no regulation that would prevent anyone from selling trust drafting services. I mean, this is America. We do believe in free commerce, and they are, you could say, a special breed of contracts. And just like any two willing people can contract to exchange a good or service for money, which is the basis of most contracts that we deal with, even the purchase of groceries, or a vehicle, or etc. Just like contracts, trusts are not prohibited to be created by anyone who has sense enough to create them. And sometimes people with a whole lot less sense than trust drafting lawyers create trusts, and sometimes those trusts work, and sometimes they don't. And so we are going to take our 11 o'clock momentary break. Okay. Resuming after our 11 a.m. break, I was saying that anyone is free to sell trust drafting services to another, or the other way around, any willing buyer is free to purchase trust drafting services from anybody else. And I was in the process of answering the question about, basically your question was, do you need a lot of property or money to create a trust? So, no, you generally don't. The trust must or should exist for a real purpose. A real purpose during lifetime would necessitate the creation of what you call an inter vivos or a lifetime trust. Sometimes they're marketed as revocable living trusts. You can create it now, you can revoke it any time, you can change it any time. That's the revocable nature of the trust, but it's also a lifetime trust. But the point is, about a lifetime trust, you should have a lifetime reason to have a lifetime trust. So let's say a couple in their 40s, married couple with children, they have a great reason to have a will, to take care of a situation of what happens if they pass away. They probably have a great reason to have a power of attorney, advance directive for incapacity. But do they have a great reason for having a trust? Just your basic, let's say, nuclear family that's supposed to never exist anymore. But you're, basically mom, pop, 2 children. What do they need a trust for? Well, we could think of reasons they might need a trust. Let's say they're loaded with money. Okay, as we were saying, yeah, that's a good reason to have a trust. But let's say one of those children has special needs. like needs an IEP. That's an independent education plan. Anybody ever heard of those? Yes, they are actually federally supported at the local school district level, and they're very kind of complex in setting up. You have to get them approved, and it goes through what are these special things needed for this special child. But can they get those benefits? Well, yes, they can, and sometimes it's best to set up a special needs trust or a supplemental needs trust if they are getting maybe disability benefits. It could be a more severe thing, maybe off the charts autism, and they need more than just an IEP, which can necessitate the need for a trust, because if mom and pop suffer a catastrophe and they leave orphans, suddenly probably insurance from a young couple would pay into an estate, and then that assistance that already would have been provided, we called it an IEP, and maybe Social Security disability income, would be eliminated. They cannot get that anymore because, in an ironic way, because their parents passed away, and now they are the beneficiaries of too much in assets, enough to disqualify them for the benefits that they were getting. But if that trust was put in place in the first place, then they wouldn't have had to go through losing the benefits, possibly never requalifying, and of course, yes, the family has to deal with a catastrophe. That's an extreme situation, but in most cases, a young family, young couple, couple children, have a very good need for a will, but they don't have a very good lifetime need for a trust. But now if you take that same couple and advance them 30 years down the road, and they have actually, now let's say 4 children and 7 grandchildren, and then they accumulated, a modest amount of wealth that's divisible. They want to make some gifts here and there, but also they just don't want to have to deal with probate. They have a very complex gifting system. They want to make sure everybody gets something, plus their charities and their friends. But some of what they have are actually operating ongoing businesses that were developed over time, and there's a desire to sell that. And how does that wind out in the process? Well, and that's where a trust can come in for, I could identify about 3 purposes right now. Number 1, avoid probate. It's about the very most common reason that anybody, most people get a trust. If you look it up, should I get a trust? It was, well, here's some reasons. Avoid probate, for one. In this scenario I'm giving you, another reason is to protect the ongoing interest or the ongoing business. Make sure that can be put into a trust. And then the trustee, if they're not running the business, they hire operating managers, and that ongoing business can be held in that trust until the point it can be spun out, sold out, wound up, transferred, bought out, or whatever. And the proceeds from that maybe pay into the estate, but the estate is not going to be probated. The estate all resides, in this scenario, in that trust. And this trust, just to kind of backtrack for a second and give you the overview, this is a trust that would be created by what was a younger couple in their 40s that we advanced into their 70s, and they have about something teen grandchildren and about 4 children. And they have a gifting scheme that's very complex. So their gifting scheme that's complex can reside within the trust, both taking care of lifetime gifting to all their grandchildren. What's the amount that's non-reportable annual per year? 14,000. So they make all these 14,000 gifts to all their grandchildren. They don't have to report a bit of it. They enjoy it during their lifetime. The trust is there. You're rolling out these gifts. They say, this is very complex. My follow-up trustee is going to be over there at the bank. And then, they're just rolling out the checks year after year. The grandchildren are very happy. Grandma and grandpa are very happy seeing their grandchildren happy. And, so that's 3 purposes right there. The complex gifting during lifetime and even after, avoidance of probate, and the protection of a business, ongoing interests. preservation of maybe family wealth. So I just kind of threw a fourth one in there. And maybe these businesses are very lucrative, but maybe they just need to be sold. You want the flexibility and versatility, and that can reside within the operation of the trust. And guess who doesn't have to be involved in that trust? The grandchildren don't have to be involved, right? And what was our original reason for creating the trust?
Avoid probate.
Right. The probate court doesn't have to get into it at all. They don't have to approve, or they don't have to bond out an executor. They don't have to get annual reports. And all these things are written into the state, law, the code, you call it the probate code. And they're not bad things. They're just protective of legacy property that would be left when somebody doesn't have a will at all. Or they do have a will and it needs extra help from the rules that are set up to protect and make sure that the family property goes to the family. But that's a good example of how these trusts work for many multi-purposes, and that would go right to that versatility point. It would also go to the protective point. And effective. Yes, effective without the approval of a probate court. But it doesn't mean that it's not going to be enforced if that trust needs to be enforced. Now, taking the question from something I said at the beginning of the class, in what court would a trust be enforced? Superior Court, yes. Yes, you were listening. And yes, Superior Court is different from the probate court. It's just the same place where you have domestic disputes, divorces, land disputes, everything else. But the point is that trusts are effective, legally effective, with the least amount of court interference. As long as you can operate a good trust, then you don't have to get the courts involved. So, for somebody who just wants, in their 70s, to not have to deal with probate because they had to maybe probate a family member's estate in the past, or their parents' estate, and go through probate and all that, often just the avoidance of probate itself, for the very cost of setting up an estate plan based on the trust that avoids probate, it's going to cost less than the handling of probate in the future. So if that's anything that you can take with you about the economic lesson of avoiding probate, there's a time to make trusts, and it's not any time. It's, and it's not for everybody. And that's one of my points here, is that, a couple in their 40s, well, what do they have to avoid probate for? They're probably going to live actuarially and statistically into their late 70s and early 80s for the male and female in this hypothetical couple here. But just because a trust can help with an estate plan or a lifetime situation, it doesn't mean the trust always should help in that plan or situation. There are often other, easier estate planning solutions than like, for example, your basic will can often help with an estate plan for this young couple. And that's what I said earlier. Once in a while, not even having a will could be a good way. I had one situation where a woman had a home. That's all she had, really. She lived in it, but then applied for end-of-lifetime support. And does that come from Medicaid? Medicare? Medicare. Thank you. From Medicare. And received that support for a few years, and then wanted to know, are they going to come after me, after my estate, having this house? She didn't have a will, but she had the house in her name. She had a child that she wanted to receive the house. So this is a non-will estate planning situation. We simply took the house, and right there we transferred it back to herself and her son as joint owners. They're joint owners now. And at the time of her passing, who would own that house 100%? The son, right. So in that case, if the Social Security Administration, through their state collection agency, is looking for that Medicare money to recover because of what they spent on that woman, they're first going to have to be the administrator and create the estate, because there's not a shred of anything filed in the probate court about that estate. There was no will, and technically there's no property, because that property went 100% again to the son, and it was not in her estate at the time of death. Yes?
Is there a time period in which you have to do what you just said so that the government can come in and claim repayment?
Timeliness is key to almost anything you do in estate planning. So in this case, whether or not the state collection agency for Social Security collecting Medicare would pursue has to do with how much they would pursue, but the time after, I think you're asking about, what about during lifetime or after death? And this was during lifetime?
No, let's assume they did it 2 years before she died.
That's fine.
Yeah.
That's fine.
There's
And
not a 5-year limit.
well, there could be a 5-year. There is. There just is a 5-year look back period.
So
Okay.
you could go back
So
and say that was entirely hers.
Yes.
That 5-year period.
Yes.
Claim all
right. Yes, they could try, but where is that deed?
Whereas what?
Where is that deed? If they try, okay, let's say 5 years before she did get the assistance, and still lived in her home, still owned it until, let's say, a week before she passed, and still she deeded it to herself and her son, and then got it recorded. And in that case, there just wouldn't be anything for the Social Security Administration to collect.
Yeah, 2 days before she dies and cause the markets that you're going to lose to the government, right? Since she did it because she was dying, she knew it. She was
Yeah,
going into the
and what
field.
about to say about when they put them into a nursing home?
Right, but what I'm saying is, okay, so just following this example, it's a case of, are they going to do estate recovery of Medicare expenses that were used, at their end of lifetime, right? I mean, that's the question. Are they going to? And I'm talking about the practical aspects of it. Where can they collect any assets from if somebody passes away? Where's the only place they can get it from?
The house, but it's gone.
The estate.
Yeah.
And is the house in that deceased person's estate? No. And it's not, because it's 100% in the ownership of the child, the son in this case. And this is something that we actually did. And I'm proud that we did it. There's nothing wrong with it, nothing unlawful about it. And the practical aspect of it is that if the only place that the Social Security state agency to collect Medicare funds can collect that money from is the estate, and the estate both never was filed and actually had nothing in it, because that house went to the son. And let's say the tangibles in the house, mother waved her hand and said, "Son, this is all yours as of the moment I said this." And so it's his. But there's nothing left in the estate. What is in somebody's estate, and here's the definition of it, the estate is composed of everything that the decedent owned the moment before they passed, and no longer can own because it remains in their name, but it belongs to their estate. So lawyers come up with the legal fiction that there is an estate, and then we file papers on it to draw the boundaries of what that estate is. Well, this estate is composed of this house right here, and we file this petition because we're the administrator, because we have no will, or we have a will and we're going to be the executor, and then we need the permission to go ahead and transfer this house or liquidate that account. And that's what probate is, and that's how that works. But they're dealing with the estate because something of value is in the estate. But in this example, this woman had nothing but the house in her name, and even the bank accounts were payable to the son upon her passing. They had a few $1,000s in it, a checking and a savings. And that's it. There weren't retirement accounts. There was no insurance. There was actually no vehicle. So at the moment of her passing, that home, which was in her name equally together jointly, we call it joint tenancy, the right of survivorship. Let me try that again. The home was a joint property. It was jointly held, joint tenancy with right of survivorship to the son. Or it could go to her, but she didn't survive the son. The son survived her, so the son became the 100% owner of that property, and her estate essentially had nothing in it. There's nothing to file. Now, the question is, will the Social Security Administration seek out estate recovery? They have a couple of really, really big hurdles. Number one, there's no estate that's been filed, and they would have to become the administrator of the estate to get the authority to ask surviving heirs, that's Heirs, heirs of the estate, that's the closest relations to the deceased, what is in the estate, what property is there, where did it go? Well, the chances of them hiring an attorney to go ahead and file that is the chance of them, paying a $5,000 to $10,000 retainer in the first place. And is it worth it to go ahead and pursue that? And technically, I've never seen them able to take a jointly held property that went to a survivor and take it away from that survivor. I haven't seen that. It doesn't mean it can't happen legally speaking, but what they're looking for is bigger money. And if it costs too much to pursue it, or there's actually nothing there, it's fine. They can go ahead and look at the deed record and see that property went to the surviving child. But are they really going to build a case to try to say that, she nefariously went ahead and transferred that jointly, and then they run a case, against, somebody who had almost nothing? They just don't run cases like that.
If the house were worth $500,000, do you think that they would pass on it?
I have doubts about that too. Even if it's $500,000, yes, I have doubts, and it would need a legal analysis for how many years was assistance being given? What kind of assistance was it? If she lived in the house, it wasn't full nursing home care. We know that, right? So it would have to be evaluated to know the level of liability that the estate or their survivors, for having received property from the estate, what level of liability they would have from that agency of the state collecting Medicare monies. But yes, questions?
Okay, I'm new to Medicare, okay, so I'm not familiar with the term end-of-life support. Is this a provision of Medicare that people sign up for and is conditioned on something? I don't
Okay, and this is where it's revealed I am no Medicare, Medicaid expert, but there's some general things that I do know where there is assisted living that one can be available to receive the assistance, and it's a matter of applying for, but they do have to, state what their assets are and what's been transferred away in the last 5 years in that application process. There is assisted living, there's full nursing home care, there's palliative care. These are classifications of care, and there's a very complex system. I would say it's complex, but it's on the medical side, at what levels do you qualify to apply? And so, but that's a good question. My point is, this is the protective nature of trust, and sometimes it may be best, let's say in one's early 70s, take this same couple and they have 2 or 3 houses, and they say, look, we're fine, we're healthy, we walk on the beach, at least when we go to our vacation home, and they're in different states. Let's put them all in the trust and leave them in there, and then our friend Joe over there at whatever bank in the trust department, he'll be our trustee. We'll make it irrevocable, just because we may need assistance later on, and we want a family legacy trust, and we'll just benefit from it, and we can live in and do anything with these homes, and Joe can spend all the money that we tell him to spend for us, and that's how that trust will operate. But then when they get into their early 80s, they can apply, and they can say, the 5-year look back, I had almost, I had a savings account, a checking account, and, but I don't have much else.
So to me, it sounds similar to long-term care insurance, which you can purchase separately. I mean, it seems like it's accomplishing the same thing.
You're saying Medicare is similar to long-term care insurance?
Well, I mean, that provision of Medicare apparently is.
I suppose.
Is long-term care.
That's a good point. And so where I come in contact with that is knowing enough of how to, I guess, safely avoid or mitigate the 5-year look-back period. I've actually had to tell clients that I can't make a Medicare assistance avoidance trust. That would actually, in my opinion, be unethical. I want them to be coming to me, or I guess I demand that my clients, in creating a trust, have a more ethical purpose than just defrauding the government. Okay, for example, anybody can mitigate their taxes, lower their taxable burden, but you're not allowed to avoid taxes, right?
Yeah.
Avoiding taxes is actually a crime. But lowering your tax burden, I mean, come on. If you don't lower your tax burden, you might need some help. In fact, I think you do. And I'm not that one. I'm not the tax person, but I can protect the assets. And that's really the point, is that in this example, if they have 3 houses and it's a couple and they do this in their 70s, and then 10 years rolls by and they set it up, that trust, they set up a trust in a way that they are not the trustees in full control of the trust, and they make it, and that's why I said irrevocable, because there are the revocable trusts, which we also call lifetime trusts. No, revocable living trust is another name for it, but you can also make it irrevocable, and those are actually for tax purposes and asset protection purposes. It gets very complex of how they're put together sometimes. If you're a high income earner and you want to go ahead and purchase an insurance policy on yourself and your spouse for a second to die policy, and you're willing to pay that premium, then that's fine. And it can pay into your irrevocable trust later on. And there's a very complex system of how it happens. But if that trust later on has, say, $20 million in it, because you've paid a pretty hefty premium every year for a good, couple, 3 decades or so, that's a very worthy and a very complex type of estate planning arrangement. And the irrevocable nature of it is a key component to it. So anyway, when we talk about end-of-life assistance or Medicare, nursing home, palliative care, that is available to everyone who participates and has paid into the Social Security system in the first place. Is it not?
Medicare does not pay for nursing home care, assisted living care. memory
Right.
care, all that stuff.
Right.
So what happens is you have to pay for that yourself. So when you run out of your money and you have no money left, then you can apply to the state for Medicaid. And Medicaid is the one that does the look back for 5 years to see if you qualify, because there's all kinds of manipulation that people do with their money to try to hide their money so
Right.
that they'll qualify for Medicaid. So that's,
Right.
people plan way ahead.
Yeah, and I'm obviously
so that
very.
so they can qualify for Medicaid if necessary at the end of their life.
Yeah. So even though I'm very mixed up in the terms and I'm exhibiting how much of an expert I'm not on Medicaid and Medicare, the point is that with careful planning, it's about protecting the assets, the family, even if it's a family home, an ancestral home or whatever, that's fine. And there are ways in which to plan so that one would be ready to receive assistance if and when they need it. It's not necessarily to game the system. But there are even whole businesses who are set up, unfortunately, in that way. But go ahead. You're going to ask a question?
I was going to ask, would that be based on the amount of time that the trust had been set up possibly?
That's one of the factors, and it's a big one. Again, going to timeliness in estate planning and creating trusts. Yes, you would like that trust to be both holding the assets for 5 years, the money, the accounts, the homes, and all that, and to some degree, at least somebody else, maybe as a trustee, maybe a child, a sibling, or an institutional trustee, because control of the assets and being the full 100% trustee, as well as being the beneficiary at the same time, is just the same thing as not having the trust and just owning it anyway. And that's the way they would see it. So that's one of the reasons for the irrevocability, or just putting somebody else in there as the trustee. Okay, so the setup of trust can be fairly complex, and that's a point I'm going to get into a little bit more. That because anybody can sell anybody else a trust, trusts are freely available, but they're still very complex. And there's a difference between, and so basically, look, I'm a trust and estates attorney. Being an attorney is something I asked before I recorded. What's the difference between being an attorney and being a lawyer? Well, first of all, those who get a law degree that's a Juris Doctor can call themselves a lawyer. They often don't, but they cannot call themselves an attorney. An attorney generally is known one who has a license to practice law. But even more than that, attorneys can be considered the ones who are actually licensed and experienced at practicing in court. Key difference between the lawyer and the attorney. So there's a distinction between estate planning lawyer or trust drafting lawyer, and let's just keep it focused on trust since we are talking about the second part of our trust discussion. But that trust drafting lawyer may be very good at drafting trusts, but as a lawyer, the litigation experience is not going to be there litigating over trusts because they only focus on estate planning, and there's nothing wrong with that. But knowing where mistakes originate and the effect of how they are remedied and fixed in court, in my experience and from what I've seen, from seeing many other estate plans drafted by many attorneys and by many lawyers and many non-lawyers, I can see the difference where things are written without knowing the effect that it will have and the possible problem that would have to be litigated in the future. And what I have noticed is that estate planning lawyers can make mistakes. Most often, they don't, that lead to litigation. Non-lawyers who draft trust and estate planning documents, I find more often than not, will have mistakes in the drafting of the documents. And sometimes they're major mistakes. I have found trusts that are inoperative or unfunded, as we call it. Deeds that have not been filed where the person had passed away. Just straight up wills that lack signatures, but were paid a very high fee to obtain. And it's not a good discovery to make, such as, that finding unsigned wills after that person who should have signed it passed away. But yes, I've seen that situation. I'm proud to say not our wills, not our trusts. They all have worked. They have not been broken, as you could say, to my knowledge. But when they are broken or when they don't work, what results is litigation. You could call it a will contest if there is a will. It's an estate dispute if there's not a will. And if it's a trust that's defective, it could be a filing of a petition asking the court to help repair or help remedy maybe the beneficiary and the trustee was doing a bad job, or maybe help everybody because the trust wasn't written right and now we need the court to rewrite some provisions so it would actually work. So the genesis, the origin of most trust problems that end up in the court are basically, number one, I guess, the lack of planning. Number two, mistakes in the drafting. And, well, that's enough. I mean, there's enough reasons as to why. But yes, you have a question.
Does the statute of limitations come into play if you have a lawyer draft up your trust and it's not done correctly, and a period of time, a substantial period of time passes from the time that the trust is done until they die?
Yeah. Yeah, so...
So would the people that engaged the lawyer originally have any recourse against that lawyer, assuming 10 years passed?
Okay. Yes. The question is, how do you get the lawyer if they make a mistake you don't find out until later? Or in other words, do clients have any recourse against the lawyer if a mistake in the drafting is discovered years after that mistake is made? And the answer is yes, upon discovery, and that's when the time runs. And it's a malpractice action. I think there might be a 2-year statute of limitations upon discovery, but also it can't just be like, oh, that punctuation is off. Ouch, that hurts. I'm suing. No. There actually has to be some kind of damage. What did this cause? Did it cause the house to go to the wrong person, or what? And so, yes, upon discovery, the clock runs, as they say. Yes.
Don't most lawyers carry errors and omissions, insurance for that type of thing?
Well,
I mean,
most lawyers should carry errors and omissions insurance. Yes. I do. Most attorneys I know do. But when they don't, I don't know. I'm not asking for their insurance. But yes, if the state bar does not require an attorney to carry E&O insurance, like the state law does require drivers to have insurance if they're driving a motor vehicle. But even with motor vehicle requirements to have insurance, do you know what percentage of drivers are uninsured? No? Anybody?
20%.
20%, yes. 1 out of every 5 drivers you see out there are uninsured. So be careful. Get your trust in place. That's just a weak analog to show that even when people are required to carry insurance, sometimes they don't, 20% of the times with drivers. But lawyers are not required to carry insurance. So my guess is going to be that more than 20% of lawyers don't have insurance. Is that reassuring? No. Okay, yes.
Question.
One last follow-up here. Yep.
Taxes.
Uh-huh.
Does the trust-
On which I'm not an expert, so taxes, bring it. Yeah.
Trusts have to file tax returns?
It depends. Does the trust have income
Administrator. who has-
upon which to, so does the trust have to file a tax return?
They get money.
And the extent is, yeah, I guess, to the extent that it has income. But if it doesn't, then probably not.
Yeah, most trusts, I would assume have some type of income.
I don't know.
Well, I'm just assuming that, but.
Well, I
It
think,
depends on what it's holding.
Well,
Yes.
Let's assume it's holding all your, whatever's material, and you
Hmm.
need cash to administer things and so forth, so
Hmm.
presumably it has cash or securities or bonds, something like that.
well, I guess the tax filing of how one files their tax return when they have a trust really depends on how the trust is set up. I believe there are several different ways that taxes can be filed. And if the trust is more or less under the control of that one person, as in like they're the trustee as well as the beneficiary, then I believe they can report their income on a schedule that would be under 1040, instead of treating the trust as a separate, ongoing entity itself. So even if there's, let's say, rental income coming in, maybe there's some, cost expense going out to keep the rentals operating, and then maybe there's a distribution of, $20,000 from the excess income to that person, and then they report it, I think, on their personal, tax return. I think that's fine. The entity itself, the trust itself, now, that could be disregarded as an ongoing interest because the IRS knows that the income came from that trust and it was reported over here and they paid taxes on it. So, but that's a big macro look at how taxes are just paid, in a really kind of blockheaded fashion. I'm no tax advisor by one, but I know that tax advisors and those who file tax returns are very creative people. And I'm sure that they've come up with 3 different ways that you could file a tax return. And I've seen one insufferable way that one client, they did form a trust, and then upon their bad advice from their CPA, they did go ahead and they started to transfer all of their accounts over to the trust itself. We had already transferred a deed or two, but just naming the trust as the beneficiary on those accounts wasn't good enough. The accountant said, well, let's follow this issuance of an EIN letter that comes from the IRS when we issue the employee ID number on that trust so you can open the bank account. Well, the trust the advising CPA went nuts, and he's like, oh, we got to report a whole separate tax return on the trust. So he called me up about 2 years after. And I'm like, what did you do that for? He's like, well, my good advisor, my CPA, told me to do it. I'm like, well, I guess I'm no tax expert, but I wouldn't have done that. Basically was my answer. So the answer to your question is, yeah, you can always file a tax return on a trust if you want to, but I don't think it's always necessary. And in most cases, it's just not. But trusts, as I said in the beginning, are versatile. There's so many different kinds, and whether a tax return is filed or not really depends on how that trust is set up, what's in it, and what income is staying in the trust, or if it's being distributed. So here's the last thing I'm going to say here, and then wrap it up. What I'm trying to tell people is that even though many people can go ahead and sell you a trust, the most value you could possibly get for a most versatile or effective or protective type of trust to meet your lifetime or estate planning needs would actually be from what you call a trust and estates attorney. Okay, there's many lawyers out there, and many lawyers draft many trusts or wills or estate planning documents, and many times they get it right, and many times they don't. But doesn't mean they can't get it right, and doesn't mean you can't get a trust from a trust drafting lawyer. That's fine. But they won't have the experience to tell you how that trust will work or how it will stand up to a challenge in the superior court. And then lastly, there are the non-attorneys that draft trusts. And I guess that's, the Wild West of getting trust. You can get them. It's like wildcatting, I guess. Or that's a bad analogy. But the point is that it's buyer beware when you go out there. And for the money you spend and the legacy that you're protecting, the lifetime assets that you put together and the family that you have and how important all that is, it's just a very strong suggestion to use the services of a trust and estates attorney that has the experience of putting these together and knows how they'll stand up if they're ever challenged by an itinerant family member, by a creditor, or by other issues that people deal with. But every person's assets, their legacy, their family, they're all different, and these trusts are versatile enough to handle many different situations. And so what I'll say is basically, if you go to a good trust and estates attorney, that attorney should only recommend a trust to a client if there is a reasonable purpose in that client's life or estate plan for that trust to exist. As said, trusts are not for everyone. They're not for everyone, but many times a will can do just fine to meet a client's estate plan goals. And whether a will or a trust is better for a client should be reviewed by an attorney who regularly drafts these wills and trusts. That's going to be the best opinion you can get as to what's going to work best for you. And my wish out there is for everybody to have an estate plan that meets their needs and actually gives them some peace of mind. That's going to be like one thing they don't have to take care of, just in case the worst could possibly happen. And thank you for listening today to this second part of Everything You Want to Know About Trusts 102. And have a great day. Thank you.